Good evening, all.
Yes, good evening.
Very good evening. So, hope my voice is clear and the presentation is visible. Okay, so yeah, let's start. Okay, so from this session onwards, maybe for the next 2, 3 sessions, it's going to be the business law. It's the module which we are going to discuss about. So, whatever course you have enrolled for. So business law is a part of, like management studies. So whether it's a BCom or it belongs to BBA or if we have taken, any stream of, like BCom or BBA, whether it's a specialized paper or a, like a general paper. So business law, you can, like see a business law module, like coming in between a topic on business law. So what is business law all about? For running a business, there has to be, like certain enforcements, uh, you have to make. That is, it should be under the law. Why? Because a business is a place or, like an event where more than one party is involved. So in that case, there is a lot of chance or there is a lot of, like space for, like allegations and conflict, disruptions and, like breaking the promises and, like even, like you can say, the confusions related to the payments, everything will happen there because people mostly know they stick on to the practices. Yes, they strictly know stick on to the business practices, but in few cases, which is like out of the control of the business owners, like few things may happen. Maybe because of the way they run the business, or because of the parties they get involved in, or because of the type of business, like they are, running. So there has to be a law, right? There has to be an enforcement. So there has to be like something which is foreseeing this like these type of like all the events which is happening in the business. Since it is like an involvement of more than two or more parties in the business event or the business transaction, there has to be a certain enforcements which has to be made, and to make sure that both the parties are safe, they don't get into conflict, and even if there is a conflict, with proper evidence and with proper you know like other whether the evidence is like a documented evidence, or it can be like other type of evidences. So based on that, the conflicts can be resolved. So that's why, every country has different business laws. It's not the same in all the countries. In India, the business law is different. In US, it's different. UK, it's different. So each and every country will be having like different sets or different guidelines for running a business. So let's see about like how the business law is practiced in Indian subcontinent. Okay. So what we are going to see about in this business law module is the business law. What is business law all about, and the source of law. So how this was formed, how this business law was like enacted, how this was formed, and what are all the like from which sources the the required, the laws and like all the acts has been like taken. And then what is an Indian Contract Act and the essentials of a valid contract, and what are all the types of contract. So, on the basis of like different specifications, the contracts like it's subdivided into like under many elements. So first, on the basis of creation and formation, that is on the basis of setting up a new organization, we have like four types of contracts. The first one being express contract, implied contract, tacit contract, and quasi contract. That is how a firm has to be set up, how a business firm has to be set up. So when a business firm is being set up, it's like a contract between the founder and the shareholders, or between the business and the government, or the like the contract between the trades that is like the tradespeople, that is the customers, clients, and the business. Then on the base of validity, so till how long this contract is valid, or how long this agreement is valid. So based on that, we have five different contracts: valid contract, void contract, voidable contract, unenforceable contract, and illegal contract. Then, thirdly, on the basis of execution and performance, it is not like how the business is being executed or how the law is being executed. And based on the performance, we have two contracts: executed contract, executory contract. And finally, on the basis of liability, that is, who is liable to whom, whether the client is liable to the business or the business is liable to the client, or if the government is liable to the business or the business is liable to the government, or between the business and the customers, consumers. So which party is liable to whom? So based on that, we have two contracts: bilateral contract and unilateral contract. So let's first understand what is a business law. It's a rule which helps us to regulate and manage our business transactions and activities system. So there has to be a regulating body, an enforcement body, so which like oversees, all the events which is happening in the business. It has direct relation with trade, industry, and commerce. For example, Insurance Act, Contract Act, Tax Act, Sale of Goods Act, Agency Act. So based on these acts, these are the small elementary acts, and based on these small elementary acts, a structure called the whole structure called the business law or business act is being like enacted. So sources of mercantile law in India. So from which sources this commercial law has been like enacted in our Indian subcontinent? The first thing is based on English mercantile law. Uh, Before the Britishers came here, that is like before they colonized India, there were sorry, there were like a certain kind of law has been practiced by the then rulers, like Mughal rulers, the other Indian rulers, and each and every province, that is before the like Britishers came, it was not a provincial system. That was a system which was being followed in the subcontinent. It was not like provincial system. There were no like different provinces in India. Southern province, like southern province was ruled by like two or three, four kings, and there was northern province which was ruled by like many kings, and like we had eastern province, we had the central province, we had like western province. So we had no like provincial system of like ruling, which was not happening here. So each and every kingdom or each and every province practiced like a certain type of like a business law. There were contracts, but that time only. By the time only, there were contracts, there were agreements signed, and usually these contracts and agreements were like it was you know like it was uh, uh, it was actually documented. No, when the paper came into like practice, that is usage of paper came into papyrus, it came into practice. So people were using palm leaves for like writing all the, like describing, writing all the lifestyle, the history of the people, the, like who's the ruler of the province, and like what people were doing, what is their staple food. So everything was there, including the laws. Especially the laws were clearly depicted. And there were tablets in the sense, no stone tablets on which these laws were prescribed. So there was a strict provincial law. There was a strict mercantile law which was followed by each and every province. So when after that, like the Mughal rulers came, so they also like practiced, like after seeing, like our Indian kings, like practicing the system. So they too have, like practiced the same kind of, like mercantile law according to their tradition. And then came the, the invaders from the west. It is like through colonization they came here. So they, in order to maintain, like a unification in the law, and to avoid any confusion by, like having a different law for different province, they came with an idea of having, like one business law or one mercantile law system. But this was not applicable to certain provinces, because like maybe because of the, like the trade relationship these Britishers were having with with those kings, with that provincial kings. But otherwise, overall, if you can see, there were no like one single business law practice system was no like being, like that was being no practiced. And obviously, the main aim was to collect taxes, nothing more than that. So how much ever like they they wanted to take away the the main resources of our country. So in the name of law, in the name of business, in the name of trade, in the name of colonization, in all the names, like they tried to they were actually not tried to, they actually took most of our resources. Then, so from basics of them, because like they were already, these Britishers were already following a kind of like mercantile law in their country, in UK, in England. So based on their law system, we like we took some sources from there. And Indian status law. Indian status law is about like how the Indian like businesses are run. Usually it is a family run business. Like in olden days, it was like a family run business, which was like passed on from one generation to another. A father will be doing, grandfather will be doing a business which will be like passed on to the elder son of the family. Then with the elder son, the other younger sons will be helping the elder son of the family. So after him it would be passed to the next generation. So this is how the business was, the business like was practiced here, the trade was practiced here in India. And there were a system, so social class system, predicting that only these people or particular group of people are eligible to practice business. Not everyone will be practicing business. So there were warriors. The warriors no belong to a specialized group. Business people, no tradesmen. They were no like other group. And farmers and agriculturists, so they were different groups. Agriculturists, like they normally don't do business, and craftsmen normally don't enter into this type of contract business. But there were certain rules which these people were following when they were trading something out of their profession. So based on that Indian status, like the Indian difference in the social class system, so few laws were taken as resources. And the general judicial decisions, especially at the end of the British rule or after the end of the British rule. So whatever happened, in the political system of our country, the judicial system, whatever, the decisions were taken by the then leaders. So based on that, few judicial system and judicial decisions, based on that few resources were taken. And finally customs and usages. So when mentioning customs and usages, again it's an old system, a very old system of like collecting taxes while people are engaged in trades. It was even before the provincial system, it was even before that. Customs like it was prevalent in the world a long time before, like from the Egyptian civilization, from the Mesopotamian civilization, the customs were practiced because people used to trade, with like different countries in the world in those days. Like Egyptians traded with Indians, Indians traded with Chinese, and Indians traded with the Gulf, and everyone was trading with India except excepting except those the far east far west people. It is like only after 1500s they found a new sea route to India. So after that trades happened, but even before that, 5000 years before, 4000 years before, the trade was happening. So wherever the trade was happening in a larger scale, custom practices were there. So based on those custom practices, old custom practices, new custom practices, so based on all these, few resources were taken. So based on all these resources, like whichever is the best, whichever suits the current business scenario, and whichever is favorable for the business people, that is who are into the trades. So these were the resources, taken from these, subjects, and the mercantile law in India was formed. Mercantile is it's not like nothing but the commercial law. Commercial commerce, it means no trade. Trade is commerce. So the trades law in India, that's how it's been enacted. So let's come to Indian Contract Act. So this act is applicable in Indian subcontinent only. This is not a general law for all the business people, like practicing all over the world. So each and every country, as I mentioned earlier, they'll be having different, business laws. They will be having different business laws. So Indian Contract Act, it was it was enacted during the British time in 1872. It was enacted by Parliament of India. That is Parliament of India. In those days, it was called as Parliament because British used to call their, the ruling body as Parliament. And the date enacted, it was 25th April. Date commenced, that is when it started. They started applying that act. It was from 1st of September. The total sections, there were 238 sections, and they extend all states of India except the state of Jammu and Kashmir, because those days Jammu and Kashmir was a uh, the whole of it was not even India by the time. It was called Hindustan. So Hindustan is the whole province of the Indian subcontinent, Bangladesh, parts of Pakistan, parts of Afghanistan, and few parts of Nepal. So everything was Hindustan. The whole province was called as Hindustan because this part it was lying between the Hindu Kush mountains and the Hind Ocean. Hind Ocean is Indian Ocean. So that's why it's called Hindustan. So, because in Jammu and Kashmir, there was no particular trade was happening because that was a hill station, and mostly it was there were people who were going for pilgrimage to through. They were using that area only for for pilgrimage purpose only. So other than that, most of the provincial states in this subcontinent, so this law was applicable. So it has two parts. Indian Contract Act, it consists of two parts. First one being general
Okay,
principle.
balance.
Guys, please mute your audio. Asghar Ali, please mute your audio.
Which is sorry, ma'am.
So the Indian Contract Act, it has two different parts. The first part is being the general principles of the law of contract, and the second one being special kinds of contract. So general principles, it just gives the general principles of how a business has to be formed. What are all the the guidelines has to be taken, how it has to be registered with the government of India, and through which body it has to be attested, and what should be the maximum investment, what should be the minimum investment, how many people can be engaged in the business, what is a shareholding business, or what is proprietorship business. There is a single owner business. So the general principles how the business has to run. And special kinds of contracts is when this business enters into a contract with a second party, that is with an individual or with an agency or with the customer, or with the government, or with another business. Then, like a kind of contract has to be, like enacted. So all those special kinds of contracts. So that it covers a section from 124 to 238. So Baki sub Baki, it would be covering, like it would cover all the general principles of the law of contract. Okay. So let's now get into deeper into what is a contract all about before getting into the different types of contract based on four specifications, right? We have seen that. Okay. The first one, that is the contract. So an agreement which is legally enforceable alone is a contract. So a contract means it is legally enforceable. Generally, we cannot say, like the all the agreements or contract. It cannot be like everything cannot be like taken like into for legal proceedings if there is any dispute. But when it becomes a contract, so anywhere at any time and like by any person, it can be like legally like things can be moved. So an agreement, it's a legally enforceable contract. Agreements which are not legally enforceable or not contracts but remains void agreements. So void agreements are those which are lawfully not enforceable, and which are not enforceable at all is a voidable agreements. It cannot be like enforceable at all, which are enforceable by only one party to the agreement. That is, either of the party, either one of the party can like take it to the law, but that it cannot be taken as a like a strong proof of like what has happened or what actually has been like discussed by both the parties. So in other words, we can say that all contracts or agreements, all contracts are legally enforceable and all contracts are agreements. But on the other hand, all agreements cannot be treated as contracts. So, and that's why all the agreements cannot be legally enforceable. And we have two types, void agreement and voidable agreement. So contract in short, it is like an offer or a proposal plus the acceptance by a party, it becomes a promise. So one person, one entity is like offering something or proposing something, and that proposal, that offer is being accepted by the opposite party. So when there is an acceptance happening, when there is a combination of offer plus proposal and acceptance, it becomes a promise. So that is what you call as contract, which is legally enforceable. So we have seen offer or proposal, acceptance, and then promise. Let's see what is offer, what is proposal, what is acceptance, and what is a promise. So offer. Okay, hope the uh, presentation is visible because, okay, fine, good, okay. Offer or proposal. So when one person signifies to another his or her willingness to abstain from doing anything. That is everything on the commercial purpose. So say for example, I am now like making an offer or I am making a proposal to a company, to an agency or to the government or to my customer that like I'm not willing to give something. I'm willing to like do something or like sell something. So based on a promise that so that other party will pay the money value for my service or the product. So this is not like the offer or the proposal. So when one person signifies to another the willingness to do or to abstain from doing anything with a view to obtaining the assent of the other person to such act or abstinence, he is said to make a proposal. So in simple words, so a party or an entity, a company, organization, or an individual, anyone, it can be an agency. So they are offering something in return for something. So there has to be something, right? So when a party, that single entity is offering something and in return they are not expecting anything. In that case, there is no reason for no like contract or agreement, right? So something has to be, like given back, taken back from the party to which the offer is made. When that party, the second party accepts it. And acceptance. So it comes under section 2B, when the person to whom the proposal is made, or to a company, to an agency to whom the proposal is made, signifies the assent thereto, the proposal is said to be accepted. So when that party, the second party, is okay with the proposal, is okay with the offer, and they are like ready to move forward with the first party, then it means they have accepted the proposal, that is accepted the offer. So combination of these two becomes a promise. So from section 2B, a promise, which means a proposal when accepted becomes a promise. In simple words, when an offer is accepted, it becomes a promise. Who is a promiser? Who is a promisee? Who makes a promise is a promiser, and who accepts the promiser, that is accepts a promise, is a promisee. When proposal is accepted, the person making the proposal is called the promiser. So in this case, like I am making the proposal, I am making the offer, I am the promiser. And the other party is like who is accepting my promise. So that person or that entity will be called as a promisee. Now, the second formula is promiser plus consideration. Promise plus consideration, it like leads to agreement. The promise has been like made and like considered. No, it is not like considered. Now it is considered. That is, I have given a promise. A promise has been made. Now I have to like consider few things. No, before getting into the trade. Before like giving the solution, giving the product or giving the service. So in that case, I am like asking the second party to like to get into the like discussion about what can be done, whose responsibility is what, and how the payment terms and everything. Then that part comes to the part of agreement. Who is agreeing to which trading function. So what are my responsibilities? What is the other person responsibility? And who is eligible to pay for what? And like how the goods can be transferred. So from which point the goods or like the responsibility of goods will be like transferred from one party to the other party. So all these things has to come to the agreement. So we have seen what is a promise. Now coming to consideration. So under section 2D, when at the desire of the promiser, the promisee, that is the second party, or any other person has done or abstained from doing something, or does or abstains from doing something, or promises to do and abstain from doing something, whatever the case may be, such act or abstinence or promise is called consideration for the promise. That is not like we are considering myself and the other party. We are considering all the terms which is involved in the trade. The first one being agreeing the product. So I am promising a product or service, the other party is agreeing to it. Or if the party wants to like make some changes in my product or service, they want some particular specifications, they can like consult with me, discuss with me. And according to my, like to my, the machineries I have, or the like the place where I do my business, or whatever, to the money what I'm going to invest in. If it is acceptable and accepting that offer, then like we enter into an agreement. But if I'm not accepting it, the product or the service, whatever I'm giving, the other party is not accepting it, or the other party is okay with the product or service, and but with few specifications, few changes in the product or service, but the first party I am not accepting to it. In that case, the agreement becomes void. There is no need for agreement at all. That is a price paid by one party for the promise of the other. The technical word here means quid pro quo. That is quid pro quo. That is something in return. So, and we are coming into terms, like something in return. Then what is an agreement? Every promise and set of promises forming the consideration for each other. When it is documented, it is being an agreement. Now, when this document, when it is like legalized in the sense, I'm running like a registered company, registered organization under the Indian business law, and the other party is also running an organization, or it can be an individual who is the like a citizen of India. I am promising that party is accepting. We are getting into agreement. We are documenting it. That is being can be enforced by law, because like I'm a registered business practitioner, and that person is like by nationality, like that person is from this country. So in that case, like yes, this agreement can be enforced by law. But on the other hand, I am not a registered business practitioner. Uh, I'm just running a what do you say, a letter pad organization. Letter pad in the sense, only in the letter pad my organization exists. Everything is like word of mouth. Everything is done over the phone call. There is no office setup. There is no proper business setup. Like there is nothing happening there. There is no trademark for my product. There is no like like an office building. Nothing. Okay, so all my business is like it's in a letter pad. Okay, fine. So in that case, it is no like it is not enforced by law. Whatever agreement I know like myself and the other party is like making into, even though if it is documented, it cannot be enforced by law. So that's the difference between no agreement and the contract. So contract, on the other hand, like yes, I have to be a registered business practitioner, and the other party has to be a registered business practitioner, or it can be an individual under like on the basis of nationality or on the basis of by birth, whatever it is, an Indian. That is a person who is in India. Or in case, like I am a business practitioner in India, and I'm giving a promise to other party, which is like somewhere in other part of the world. In that case, also, like when that person files a case, or that organization files a case, or like case against me, either in their country or in my country. So yes, on few considerations, it can be enforced by law. Then the third, formula is agreement, which is enforceable by law. It becomes a contract. That is when the agreement, which can be like enforced by law, that is by the proper business practitioners, it becomes a contract. So what is a contract? An agreement enforceable law is a contract. Now, so this is how like the business like it the whole business the when both the parties are like entering into a contract, this is how it is done. The first one is proposal is being made, and then a promise is being made, and the things are being considered based on the product, based on the price, and based on the time for delivery, date of delivery of the product, and the place of delivery of the product, and to whom, to whom it has to be delivered, whether the product or the service, to whom, to which person or to which entity, it should reach. So those things are being considered. And then once everything is discussed by both the parties, they come into an agreement. So agreement, that can be divided into two: legally enforceable. When it is legally enforceable, it becomes a contract or a voidable agreement. But when it is not legally enforceable, it becomes a void agreement. So this is how the agreement or the contract it can be enacted. So essentials of a valid contract. What are the main essentials? How to make a contract so valid? So as per section 10, all agreements or contracts, if they are made by free consent of the parties. So what does that word say? Free consent. That is, I am free to do the trade, and the other party, opposite party, is free to accept my product and service. So it is not under pressure, or it is not under like any of like through oppression or by any other illegal means, but completely free consent. Both the parties, we are into free consent. Competent to contract for a lawful consideration and with a lawful object, and not hereby expressly declared to be void. That is like Why a business contract is being made, why two parties enter into contract, because we believe that no, like, yes, we can run no, like a genuine business. The trade can be no, like done genuinely. So we both the parties has to follow few things ethically. Ethical consideration has to be there, and ethical practice has to be there. Ethical business practice has to be there. Whatever is promised by either of the parties, the promises has to be fulfilled. And after the sale has happened, after the trade has happened, if it is like something more else is being agreed between the two parties, that is after sale service, or no, like a free service for next 1 year or 2 year, or a return of the damaged goods, no, like by any means, whatever it is, no, like till no, like till the particular date, till some particular date, no, that is being mentioned on the agreement. So, lawful object and not hereby expressly declared to be void. So, we don't get into a contract or an agreement or to a business deal thinking that no, it's going to be void, thinking that no, it's going to fail. No, we believe no, like, yeah, it's going to be a success one. And I believe no, the other party is going to practice ethical business, that is ethical way of no, like running the, I mean, ethical way of no, like accepting the offer, and the other party is believing that I am going to like do the business ethically till no, the final product or service is being delivered to the party. So, or based on this trust, based on this truth, or based on this genuine no, like act, the business is being made, the contract is being made, but not on the consent, not on the context that it's going to be void. So finally, the whole formula for no, like a valid contract is offer plus acceptance that gives to the promise. So this promise plus consideration, it forms the agreement. So this agreement and plus like an agreement which is no enforceable by law, it becomes a contract. So this is how no, the business practice is done between two parties or more parties. Essential elements of a valid contract. We are going to see one by one. If if there is no like enough time, we can complete all these things, or otherwise no, like no problem. So at least half I can finish, the remaining half we can see in our next discussion. Okay, so essential elements of a valid contract. First is offer and acceptance. So an offer is made and it has to be accepted by the other party. Legal relationship. So how it's going to be a legal relationship? So whenever no, like an agreement is being made, whether it's no like void, I mean voidable agreement, or no like uh, or no like something which is no enforceable law by law, whichever it is, there is a legal relationship no, which is being formed no, between the two parties. So no, like I'm a no, like a registered business practitioner, and I am no promising something, I am offering something, and the other party is accepting it. So we enter into a contract. So it becomes a legal relationship between that party and myself. So this is how no, like the legal relationship it no, like forms. Consent ad item. So consent is no, like the consent of no, like sticking on to the moral practices, ethical practices, to the promises which are being made in the trade. Free consent. Nothing, no, like no pressure. No one is no pressuring me to do the business, or the pressuring the other party, no, like, suppressing the other party to get into the business with me or get the products or service from me. So it has to be a free consent. Capacity or competency of parties, it depends on the what type of business or what type of trade is no, like which is being happened, which is being done. Lawful object, and then no, like lawful consideration. So all these will be in the contract, the object and the consideration. Certainty and possibility of performance, agreements not declared to be void, and legal formalities. So with all these essential elements, a valid contract is formed, it is enacted. First, what is offer and acceptance? In order to create a valid contract, there must be an agreement between two parties. An agreement involves a valid offer by one party and valid acceptance of the same by the other party. This can be documented, yes, either by email or through any other physical documentation, or by like any means, this can be documented. Uh, After documenting this, after promising everything, for any reason, if the other party is not practicing any ethical or a moral the guidelines, then this documentation can be used for law enforcement. Second one is legal relationship. The parties must intend their agreement to result in legal relations. This means the parties must intend that if one of them fails to perform the promise, either I or the other person who has accepted my offer, so fails to stick on to the promise. So that party shall be answerable for that failure in the eyes of law. So if I am failing to give the failing to give the deliver the product or service on time, I am answerable. Under the law, I am answerable. So I can't say that is how I do my business. No, this is not the moral way of treating my the customer or treating my my business partner or whoever it is. With whom I'm doing the business or the trade. So no, if I'm promising something, I have to stick on to it. So otherwise, if I fail in that, I am under the law. Duties and rights should be legal and not merely moral. Not just moral, but everything has to be legal. An agreement of a purely domestic or social nature is not a contract. It is an agreement of purely domestic or social nature. That is not a contract. That is not considered as a contract. So consensus ad item. The minds of both the parties must be ad item. That is, in other words, the two parties must have agreed about the subject matter of the contract at the same time and the same sense. So both we both get into the an agreement. We know what is the process. I know what is the process. I'm making the other party to understand what is the process. Now, after having a clear idea about what will be done on particular date, time, or specific time, within everything, every specifications is there. So we know yes, we say yes to the trade. Free consent, that is permission or willingness to get into the trade. An agreement must have been made by the free consent of the parties. Consent is said to be free when it is not caused by coercion, under influence, fraud, misinterpretation, or mistake. Uh, Sometimes, few businesses, yes, it may happen in corporates or it may happen in few government contracts, that under pressure or under someone's influence, no influence from the higher authorities, or misinterpretation or by mistake, sometimes without consent, few parties will enter into trade with the other party. That is both if it is both the parties, at least either of them will not be having a full consent about, they are not fully willing to get into the business with the other party, but because of pressure or because of coercion or because of influence from higher authorities, or because of some misinterpretation, believing that this would happen, but actually practically that is not possible, or by mistake, whatever reason, sometimes, they unwillingly get into the trade. This also happens. But actually, as per the law, both the parties have to give full consent to get into the trade. Capacity. The parties to a contract must have capacity, that is, legal ability to make valid contract. Section 11 of the Indian Contract Act specified that every person is competent to contract provided. So whichever party is now mentioned in the contract, it means they are competent enough to know, when the promise is not made, that is not fulfilled, when the promise is not kept, within that specific time, or this is not the product, which was not mentioned in the contract for whatever reason. So I should be, eligible enough, or I should be, having the capacity to the coerce a situation. That is how I have to manage the situation. I should be eligible for that. If I'm not eligible for that, if I am not like no, I'm not in a position to know like resolve the conflict no which happens no after that incident. If I'm not making no not fulfilling my promise, so in that case no it means I am not having that ability or not having that capacity. Maybe no I would have no like I have gone for bankruptcy, or my business has no like yes it has been no like nullified or whatever reason. Only in those cases no I may lose my capacity, or sometime, or if that is not happening, I should be having the full capacity and legal ability to make a valid contract. That is, I should make myself no like eligible for fulfilling all the duties whichever I have promised. So, competent to the contract provide is of the age of majority according to the law, which he is the subject, which is the person is the subject, who is of sound mind and is not disqualified from contracting by any law to which no that this person is a subject. Lawful object. The object of agreement should be lawful and legal. Consideration or object of an agreement is unlawful if it is forbidden by law. This law doesn't allow this, but you're no like making it no in your business contract. It is forbidden by law. Is of such nature that if permitted would defeat the provisions of any law, or it is fraudulent. Second case is if it is a nature, that is in if at all in case the law accepts it, that is it is forbidden by law, but for any other reason, maybe due to no political pressure or to know like for any other reason or any for any consideration, if they are accepting or permitting it, so it completely changes the provision of the law, completely changes the actual provisions of the business contract law. So that shouldn't be happening. Then, if it is fraudulent, so I shouldn't know like get into any like fraudulent practices of like running the business, or the other party shouldn't know like do any take any fraudulent measures to know like to to make my or to make more money out of like my promise which is being given to the other party. Involves or implies injury to person or property of another. Any of us know like we are not like trying to know like or we have damaged the other person or the property, or no like not only the property but for the no like the goodwill whatever no when we are trying to damage each other, or either of us is trying to damage the other person's no like property or no the fame or whatever it is. If I'm no like getting into some illegal measures for doing that, so again no it is no like void. Then court regards it as immoral or opposed to public policy. If court decides, if court feels that, that is the law feels that it is completely an immoral practice and or opposed to public policy, yes. So it becomes unlawful practice. So lawful consideration. All contracts must be supported by consideration. Consideration means something in return. So we are not something no we are getting into consideration. So I'm considering no like this product, the party is accepting it. So yes, I'm no like in return no the party will be paying for my product or the for the service. So something in return which is called quid pro quo. It can be cash or it can be an act of abstinence. It can be past, present, future. It can be like in any of the like timeline. However, consideration should be real and lawful. A consideration must not be unlawful, immoral, or opposed to the public policy. Not expressly declared to be void, possibility of performance, necessarily legal formalities. So a contract may be oral or in writing. How come oral contract is legally enforceable by law? Only when it is no like physically documented or no like digitally documented, it can be legally enforced. But how it can be like when orally like a contract is being made, how it can be like legally enforced. Yeah, there are many provisions now to support that this context that like whole thing, the business dealing can be recorded, can be video recorded, with no like the clear, no like the sound, the voice of the parties. Yes, that can be taken as a, like evidence for no the trade which has happened. So elements of a valid contract, this we have already seen, but again, no, like let's go for a quick review before we conclude today's session. So agreement. Agreement is between something between two parties. When a single business is doing something and which is not promising anything to anyone else, it means no, there is no agreement. If I'm a no like a say for example, I'm a freelancer. So freelancer, or if it is no like someone who is running the business for the benefit of that person, own his or her own, running a YouTube channel. So in those cases, no, like there is no particular, no, like a contract or something, no, a voidable agreement is happening there. Okay, the only agreement or contract here is between the, the channel, the YouTube company and you. So you shouldn't like post anything which is immoral. So few practices like it should be like avoided. So these are the few like contracts or the agreement you get into. Finally, you will know like checking the like tick box, that is like I accept to all the terms and conditions. So that is the agreement between you and the other party. Otherwise, there is no need for agreement. So agreement is like made by accepting the offer, that is which is having a legal relationship between two parties. And next one is consideration, that is legal detriment, lawful and bargained for. Consideration is considering the product, that is consider is nothing but like promising something and getting return for that promise. That is consideration. Can be for a product, it can be for the price I'm willing to like give for this price. Other party is agreeing to that price, or the other party is negotiating for no lesser price. I'm agreeing to it. Yes, then this is a consideration. Or I'm like giving the other party the timeline to deliver the product or service. Other party is agreeing to it. Then yes, it's consideration. Or the other party is not agreeing to it. Wants like earlier delivery of the product and service. I'm agreeing to it. Again, it's considered. So this is consideration. Reality of consent, that is not valid. That is reality of consent is when fraud practices are like done, and misinterpretation of like the data in the contract. So that has to be avoided. Duress, undue influence, mutual mistake. Mutual in mistake, it don't happen actually. It can be either of the parties' mistake or misinterpretation, but in sometimes like rarely, so mutual mistakes may happen. That is mutual misinterpretation may happen. Then legally, that is then as capacity, that is not valid. So infants. So this business contract is not applicable to infant, that is younger people, and anyone below 18 years. Yes, that they are not like valid to make a contract. So under 18 years, like they are not eligible to get into a contract. The mental status of the person, when the person is not like mentally strong, yes, that is completely like void. And when the person is like completely like illicit, yes, that is like it is completely like void. And then corporations in the sense like uh, so consider this one, like any kind of entity, like which is doing, like an FDI in another country, or like say they have like stepped open their like operations in like other zone. So in that case, only when they are like registered under the law, and only when they are like say a foreigner is coming to India for any business trip, or for like a tourist trip, or whatever the reason. So that person is like promising something, offering something to a client in India, and in that case, that person is not a registered business practitioner of India, right? So he may be or she may be a business person in that person's own country, but not here in India. So in India, that person is not treated as a registered business practitioner. So in that case, now it's completely becomes void. And then is legality. So this legality, it has to be objective, it has to have some subject matter. So there should be some reason, right, to get into, to consider, to get help of the law, to resolve the dispute. So without any subject matter, you cannot, take that contract and, you ask the law to help you. So there has to be some subject matter. And finally, writing. Not only writing, it can be an oral documentation as well. Because it can be videograph, the whole trade, the whole everything can be videographed. So that is also it can be treated as a then an authenticity for legally enforcing. So yes, we have come to the end of the session. Still, we have more, to go through. Maybe we will try to cover up in, two more sessions next week and the other week. So if you have any doubts, you can stay back and you can ask me, and or otherwise you can leave the session. We'll meet next week. I'll be here for next 2 to 3 minutes.